The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation building series, The Law and You. This is program number 922. Coming to you on Monday the 17th of December 2018. On this program, I will speak to you on the topic, Administrators are to follow the law. But before getting into the topic, a few preliminary comments. Firstly, and as usual, I would like to send out my deepest condolences to all families which have suffered recent bereavements. And I think first and foremost of the family of the late Archdeacon James Harry of the Spiritual Baptist Archdiocese, who died last Tuesday and would be laid to rest on Sunday the 6th of January. And special condolences also to Sister Terry Williams, the widow of Errol Williams, who died a few days ago. And next, I would like to wish a Merry Christmas and a Happy New Year to all of you, because this would be the last program for the year of the Law and You. There will be no Law and You Christmas Eve night, which will be next Monday night, nor All Year's night, which will be the following Monday night. So the next time you will see me on the program, Davy, would be on Monday the 7th of January. Hence, I'm taking the opportunity to wish a very Merry Christmas, a blessed Christmas to one and all. And do hope you have a very good time. But in saying so, let me remind my fellow diabetics that you are to maintain your diets. You see, we know it's Christmas time, but our bodies don't know that it is Christmas. So our bodies do not make allowance and say, well, it's Christmas so we could eat and drink and be merry and do what we want to do. No, you still have to be cautious, be sensible, and follow your diet still. All right? Now, I wish to send belated anniversary greetings to a couple who on Saturday last, 15 December, celebrated 45 years of marriage. So on the occasion of your 45th wedding anniversary, belated happy anniversary to Mr. and Mrs. Panel R. Campbell. I know what gets you with that one. And yes, my brother Brennan, yes, I got my barrel. I know the first thing you're going to see when you look at the program tonight, you say, boy, P.R. got a barrel? Yes, P.R. got his Christmas barrel. Excuse me. And finally, let me say happy birthday to one of my godchildren, my goddaughter, Tiffany Pear. Happy birthday to you, Tiffany. All right. Administrators are to follow the law. Who is an administrator? I am speaking in the context of somebody who gets the authority from the High Court to administer the affairs of a deceased person. Basically, in law, there are two types of personal representatives of the estates of those who die. One, an executor, or the feminine is executrix. So if it's the executor is a woman, she's normally referred to as an executrix, TRIX, and the man executor. That is somebody named in a will to carry out the wishes of somebody who has made the will and has passed on. And the second type of personal representatives is an administrator. Again, the feminine of administrator is administratrix, if it's a woman. But if it's man and woman, it's joint administrators. You refer to them as administrators. Because when a person has died, and that person has left anything of substance, which is called the person's estate. Doesn't matter what it is. It could be just a vehicle, could be just some furniture, could be some jewelry, could be some wares, could be a house and land. Whatever a person dies and leaves behind, which is capable of being passed on to somebody who is living, all of that property is called the estate of the deceased. So the law says, since the dead cannot administer the affairs of their estate, then if the deceased person has left a will, that will would say who is supposed to be responsible for organizing the affairs of the deceased person so that those who are entitled to get something out of the estate can get it. And therefore, if a will is made, the will would name somebody as executor or executrix, as I told you before. If the deceased person has not made a will, the law says what should happen to the deceased person's estate, who should get it. Normally, close relatives, and only highly unusually strangers. Normally, the close relatives of a deceased person who has not made a will can become the administrators of the estate. How does one become an administrator? Well, you apply to the court. There are lots of documents to be organized, signed up, but basically, if the deceased person, for example, leaves a spouse and children, then normally the spouse who is surviving would be the first one in line to apply for letters of administration. If the person who deceased and didn't leave a will was not married but had children, then the children, assuming they're of age, would be the first persons who have the right to apply to the court. If the deceased person left no spouse, no children, then the parents or one of the parents of the deceased person, if no parents, then a brother or sister of the whole blood, and then brother of the sister of the half blood, and so on and so on and so on. Grandparents also come in. So fundamentally, somebody dies, doesn't leave a will, then one of the close relatives would go to a lawyer and have the papers done up and lodged at the registry as an application for permission to distribute the estate of the deceased person. And the document by which that application is granted and approved is called, well, there's no singular, it's letters of administration. Now, very often somebody hears about that and goes to a lawyer and say, well, I come to get a letter to administrate for my deceased father. Well, it's not a letter saying there, so and so. It's simply a certificate from the registry naming the person who is to be appointed administrator, naming the deceased person, the date of death, and listing the property of the deceased person. And the application would also have in the names of the persons who are supposed to get from the estate of the deceased person. Now, very often, because more than one person might qualify to apply for a grant of letters of administration, the question arises, well, who is the best person, who is in the best position to file an application? Suppose the deceased person left several children. Lawyers would advise the children, look, you all get together and decide which of you would be acceptable to the rest as the applicant for a grant of letters of administration. Hasn't got to be one person. 2, 3 persons, 4 persons can apply jointly and say, we want a grant of letters of administration. Normally it's 1 or 2. The registry has to ascertain, firstly, that the person who has applied for the grant of letters of administration is qualified to apply. So that if the person says, I am the son of so-and-so who is now deceased, evidence has to be lodged to prove that the applicant is indeed the son of the deceased, normally the birth certificate. If the applicant says, I am the spouse of the deceased person, you produce the marriage certificate. So there must be some document to provide evidence that the applicant is really and truly qualified to apply for the grant of letters of administration. So that assuming you get over that hurdle, you next have to identify what items make up the estate of the deceased person. A vehicle in the deceased person's name, a bank account, the proceeds of an insurance policy, land, house and land. Documentary evidence has to be produced to show, yes, these items of property, both personal property and real property, belonged to the estate, to the deceased person during the deceased person's lifetime, and now form part of the estate of the deceased person. And then the question arises, okay, who are all the beneficiaries who are legally entitled to share in the estate of the deceased person? Well, the law has rules providing for that. Therefore, the beneficiaries are identified in the documents. You would have noticed in the last 2 years that when you open the newspapers, you would see an application, a notice saying that an application for letters of administration to the estate of so-and-so deceased has been filed by so-and-so. And if anybody has an objection to that, you have 14 days from the date of the second publication of the notice to lodge your objection with the registry. Now, before that, there was no means of knowing who has applied unless one went and searched the documents of the registry, the registers, to see if a grant was issued in the estate of so-and-so. And that led to some fraud in several of the territories of the Eastern Caribbean. So the Chief Justice, 2 years ago, formulated some probate rules. And one of those rules says, anybody who has applied for a grant of letter of administration has to put notice of that application in a newspaper. And that notice must advise the general public that so-and-so is planning to or has applied, and giving the general public the right to file an application to oppose the grant. That is a very healthy development. Much more expensive because it costs money to publicize, and generally the probate fees have gone up, but still it is a step in the right direction. Therefore, nobody can apply practically in secret. I say practically because an application for and a grant of letters of administration is a public document. Anybody can go to the registry, access the books, and you go through and look for the name of so-and-so deceased to see if anybody has applied for a grant and so on. So the documents, once you are filed, the public have a right to go and search and see. So let us suppose that somebody has died intestate, that is not having a will, and a close relative, son, spouse, parent, uncle, has applied for a grant and gets a grant. The person will get a document saying that practically the Chief Justice has appointed you, call it by name and address, to administer the affairs of the estate of so-and-so deceased, according to law. Now that is what I want to deal with in the next few minutes on this program. Because when the registry issues a grant of letters of administration to somebody to administer the estate of a deceased person, the person to whom the grant has been issued has legal responsibilities. That person has to follow the law. The person has to administer the estate of the deceased person according to law. the person isn't given the right by the registry acting on behalf of the Chief Justice to take the property of the deceased person and do what he or she likes with it on grounds that you have a document saying you got letters of administration. No. Once you get a grant of letters of administration from the court, you have a duty to carry out what the law says you have to carry out. And one of those is that the persons who have been identified as beneficiaries of the estate have to receive their share. You can't take all for yourself on the ground that, oh, I am the administrator for the estate, and therefore I have the right to do what I feel like. Mm-mm. And there are cases in which persons have become administrators, that is, they have got a grant of letters of administration to the estate of a deceased person, and have proceeded to do their own thing. No, no, no. When a grant of letters of administration has been issued to a person, that individual becomes a trustee of the property of the deceased person with the responsibility to distribute that property according to law. Now, on the other hand, whatever expenses the person has incurred in getting the application together and in carrying out the other duties, those expenses have to come from the estate. So the administrator is entitled to get back what he or she has spent from his or her own pocket. If it is money that came from the estate in the first place, well, there's nothing to get back because it wasn't your money in the first place. But if you use your money to administrate, really to administer, but we use the term loosely, you're entitled to get back your money. Sometimes the estate of the deceased person hasn't got the liquid cash that you could use to be reimbursed, and therefore one or two items might have to be sold. Your lawyer will guide you through that process. But the basic thing, and the point I want to leave with you, is that an administrator is not free to do as he or she pleases when he or she has got a grant of letters of administration appointing him or her as the administrator of the estate of a deceased person. And in cases where there is credible evidence that an administrator has misused his or her authority, then anybody who has been the victim of that misuse, that is, for example, one of the beneficiaries to whom nothing has been given, even though a share of the estate should have gone to that beneficiary, can go to court and complain that the administrator has misused his or her authority, has not done what he or she ought to have done, or conversely, has done what he or she was not supposed to have done. And if you can satisfy the court, that your allegations are correct, the court can pass orders to compel the administrator to do that which the law says should be done. Excuse me. And therefore, the gist of what I am saying is that when a person applies for a grant, among the documents that he or she has to sign as part of the application process is called an administration bond. He or she has to sign to say, look, I would be fully responsible to give an account of my administration. In other words, I'll be fully responsible to carry out my legal duties. And if I don't, I would be liable to penalties. And the bond will require at least one or two more persons to co-sign. To take responsibility for the person who is applying. So that not only has the applicant got to sign, the applicant has to provide usually two more persons to sign to say, look, we will see to it that the applicant carries out his or her duties under the law, otherwise we ourselves would be liable. If, for example, money is misappropriated, then the persons who sign the administration bond are just as liable as the administrator who has misappropriated the money. Also, when the person is applying, the person has to, as said before, set out the names of all the beneficiaries and the proportions of the estate that they're entitled to, that each beneficiary is entitled to. So that when a grant is given, it is given on the strength of what you, the applicant, would have said in the papers you have signed. And not just sign, you sign them at the registry in front of the registrar. So you can't say you didn't know what you were signing or somebody tricked you. Therefore, in summary, there are serious responsibilities which the law attaches to the office of administrator of the estate of a deceased person. And those who are going to apply for a grant of letter of administration ought to understand what their responsibilities would be and what will happen if they break the obligation to carry out those responsibilities according to the law. Okay? All right, well, just remains for me to once again wish one and all a happy, blessed Christmas season, bright and prosperous New Year, and remind you that there will be no law and you Christmas Eve night or Holy End night. This is the last one for the year. And if it be the will of the Lord, I will be back with you on the night of Monday, the 7th of January, 2019, for the continuation of this nation-building public service series, The Law and You. Until then, may the Lord continue to bless us all.
The Law and You. A look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You. Presented by lawyer panel R. Campbell QC and brought to you on SVG-TV as a public service.